Good morning.
Good morning.
Welcome to the First District Court of Appeals. Today we have three cases that are scheduled for argument. The first case is case number C210180, Marjorie A. Kenny, trustee et al. Versus Board of Zoning Appeals, Village of Newtown, Ohio. If parties can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Emily Supinger on behalf of the Village of Newtown, and we're ready to proceed.
Good morning.
Good morning, Your Honor. Kathy Ryan on behalf of Marjorie Kinney and the Cincinnati Soccer Club, and I am ready to proceed.
Good morning. I'm going to mispronounce. Please share with me your name again.
Supinger.
Supinger, thank you.
Yes.
Attorney Supinger, would you like to reserve time?
Yes, I would like to reserve 2 minutes, Your Honor.
All right, you can start whenever you're ready.
Okay, thank you. And may it please the court. My name is Emily Supinger, and I represent the appellant, the Board of Zoning Appeals, Village of Newtown, Ohio. We are here today because the trial court, without any legal analysis or evaluation of the evidence, erroneously ruled that the BZA's decision to deny appellee's request for a conditional use permit to operate a soccer club training facility was unsupported by a preponderance of substantial, reliable, and probative evidence on the record and was error as a matter of law. The decision was issued by the magistrate and adopted over objection and without change by the court. There were clear errors in the magistrate's decision. And while this court's review is more limited than the trial court in an administrative appeal, this court may reverse when the Court of Common Pleas errs in the application or interpretation of the law, or its decision is unsupported by a preponderance of the evidence as a matter of law, and that is the case here. The application at issue was submitted by the appellee Cincinnati Soccer Club on property that's owned by the Kinney family in Newtown, which, despite being a residential neighborhood, is located on Church Street and has high volumes of traffic during rush hour. The appellees proposed to use the property to conduct soccer training sessions every weeknight in the spring and fall between 5 p.m. and 8 p.m. The surrounding properties are all residential homes, with the exception of St. John Fisher Church. And one aspect of this case that makes it unique from most other zoning cases is that the soccer club used the property for this same purpose for 2 years before it ever applied for its conditional use permit. And only did so after being told so by village officials. This 2-year window afforded the neighboring property owners an opportunity to actually assess the impact that the use would have on the neighborhood and testify before the board regarding their experience living next to the use. Under the Newtown Zoning Code, an application for a conditional use permit cannot be granted unless the board makes specific findings of fact based on the particular evidence presented to support conclusions that the conditional use meets 8 specific requirements. And to be very clear, an applicant has no entitlement to a conditional use in the same manner as a permitted use. There is no presumption in favor of the property owner. In this case, after a 6-hour hearing and testimony from 17 witnesses, the board concluded that the soccer club's application failed to meet 3 of the listed conditions for a conditional use permit. The first, section 36.3C3, that adequate access roads or entrance and exit drives will be provided and designed to prevent traffic hazards. Section 36.3C6, that the location and size of the conditional use, the nature and intensity of the operation involved or conducted in connection with it, and the size and the location of the site with respect to streets given access to it shall be in harmony with the appropriate and orderly development of the district in which it is located. And finally, the catch-all, section 36.3C8, evidence that the conditional use desired will not adversely affect the public health, safety, and morals. The magistrate reversed the board's decision without any analysis of the evidence that was presented. The entire decision consists of conclusory statements and contains no rationale for overturning the BZA's decision, and clearly no deference was afforded to the board as the fact-finding body. The court additionally did not provide any analysis of how the soccer club had met its burden of establishing that it had met the legislative requirements of the Newtown Zoning Code. Your Honors, in a nutshell, the decision signed by the magistrate provides that because the soccer club had a traffic expert and the citizens who testified in opposition did not, the BZA's decision is unsupported by a preponderance of the evidence. Specifically, one of the only references to the evidence contained in the magistrate's decision on paragraph 21 states, quote, "The expert testimony presented by the appellant's expert was not be rebutted by any qualified experts." This is not the standard. Zoning cases are not a battle of the experts. There is a reason that zoning boards are comprised of members of the community, and affected property owners have a right to attend a meeting and present their own evidence. It's because they're deemed to have specific knowledge about their own community. The evidence in this case was not complicated. Evidence does not become any less credible because it comes from a lay person and not an expert witness, especially when the testimony of the lay witnesses is based on actual real experiences. Moreover, the magistrate's decision ignores the testimony of the Newtown police chief and the report of the village engineer, both of whom are more familiar with the traffic patterns in the village and along Church Street than the soccer club's paid expert. Nonetheless, and what is striking about the magistrate's decision is that the board's decision is actually consistent with the evidence presented by the soccer club's own expert in reaching many of its conclusions. It was only the ultimate issue of fact, the issue that was within the board's purview to decide, not the expert, that the board agreed with Mr. Flume, the soccer club's expert. With regards to the issue of traffic, the board agreed with Mr. Flume that the proposed use would exacerbate existing traffic conditions by adding 200 trips a night, including 100 additional trips during the peak traffic hour between 5 and 6, which would represent a 12 to 13% increase over existing conditions. The board agreed and adopted Mr. Flume's testimony that traffic on Church Street is busy and gets backed up, that traffic continues to increase on Church Street, that there are times when the traffic could exceed his estimates, that other than a major reconstruction project, there is no solution to the current traffic situation on Church Street. The board also adopted—
You know, that last fact that you articulated,
Yes.
it seems to me that that was something that the magistrate and the trial court found, I don't want to say persuasive, but they seem to put some emphasis on that. In other words, that the traffic condition in Church Street, regardless of the soccer activity, was quite high. And so it seemed as if that seemed to be something that the trial court relied on in the magistrate.
Well, what I would say is that it's hard to tell exactly what the trial court relied on, Your Honor, because the decision is devoid of any factual analysis whatsoever. It simply provided that there were experts who testified about the traffic conditions, and that the individuals who testified that their testimony was speculative about what would happen to the traffic. And I think in this case, when you have a residential street that already has high volumes of traffic, the zoning code specifically provides that in order to grant a conditional use, which is not a permitted use, this is a use that has to be analyzed with respect to where it's being located and whether or not it is compatible with surrounding uses. We have to look at that situation and determine whether or not it fits. And in this case, the appellee's own traffic expert said traffic is high and it's going to be increased. Now, he decided that the level of service after the increase in traffic would be a C rating, and that's acceptable, but that's not a decision for the expert to make. That's a decision for the board to make, whether or not that's an acceptable level of traffic. The expert also agreed that the offset of the location of the proposed drive to Edith Street created a safety hazard, and that it did not comply with the required spacing under Hamilton County Access Management, and that the offset of the street would create potentially gridlock if there were cars turning left onto Edith Street and cars trying to turn left into the proposed access drive at the same time. And one of the issues here is that the timing of the practice. Let's talk about that 5 o'clock to 6 o'clock hour. We're talking about a very concentrated time period in which we are going to have 50 parents dropping off kids and leaving. And then within an hour and 15 minutes, 50 parents showing up to pick up kids and leaving. It is at the exact time, Monday through Friday, that this street experiences its highest level of traffic, its peak hours, which is what the traffic expert testified to. And this was the only witness that the soccer club put on regarding traffic. However, many of the neighboring property owners testified about the traffic as well as the police chief. The magistrate's decision completely dismissed this testimony as speculative with no explanation, but it was not speculative. It was based on direct evidence. The neighbors who testified presented their testimony about their experience trying to get in and out of their driveways during peak traffic hours. They presented photographs depicting the traffic congestion on Church Street with cars lined up all the way up the street. One woman testified that she had walked to the corner of Route 32 in Church Street faster than she could drive during those peak hours. They also testified that previously, when the soccer club had used the property, that they witnessed soccer club members trying to make U-turns by cutting down other residential streets in order to try and avoid the traffic, which had added to additional conflicts with pedestrians and cars. The second issue, the second factor that was not found was whether or not this was that the location and size of the conditional use and the nature and intensity of the operation was in harmony with the appropriate and orderly development of the district in which it's located. The only evidence presented on this issue was from a zoning expert, Mr. Sorrell, who testified that the principally permitted uses, such as a school or a church or a park, would be more impactful than the conditional use. This argument's invalid on its face, and it conflates the concepts of a conditional use with a permitted use. These are separate and distinct concepts under zoning law. And the conditional use at a case here must be evaluated on its own merits and not by comparing it to what impact a school would have or what impact a park would have. And regardless, those principal uses the board found, a school or a park or something along those nature, would be more mutually beneficial to the surrounding property owners. Here, not a single resident of Newtown testified in favor of this. The people who showed up and testified in favor of this application were parents of soccer club members who came from Anderson Township and other areas to support the soccer field. And to be very clear, this is not, the appellees kind of depict this as, something for the kids. How could the court possibly rule against something that's good for kids? This is an expensive club. It's not for your average kid. The cost to play a season are between $1,100 and $1,500. It's got some exclusivity to it. It's not something that necessarily all the neighborhood kids could join in and participate in. The neighbors also testified that during the 2 years that the soccer club was there, they experienced noise associated with the use, kids yelling and cheering, tires squealing, horns blowing. And the police chief testified that the soccer club's prior use caused problems, that the soccer club was not a good neighbor to the people who lived there. Your Honor, I see my 13 minutes are up. Would you like me to just say a couple more sentences here?
Just wrap up if you don't mind.
Yeah, sure. I guess the point here is that the trial court failed to recognize that the facts in this case are largely undisputed. It is the ultimate decision, the decision that the board was entitled to make, that the experts did not get to make, is where the court failed to apply the proper standard. And the conclusion was factually and egregiously incorrect, and the trial court decision should be reversed. Thank you.
Thank you. Attorney Farah Ryan, whenever you're ready.
May I please the court? My name is Kathy Ryan on behalf of Marjorie Kinney and Cincy Soccer Club. Good morning. I believe that the main gist of this case is, as Ms. Supinger mentioned, Cleveland Clinic Foundation versus BZA states that the trial court, the appellate court may only reverse the trial court if the trial court errs in its application or interpretation of the law, or its decision is unsupported by a preponderance of the evidence as a matter of law. This is then supported by the fact that there are evidentiary matters here that the magistrate correctly concluded are unsupported on the record and are not probative of forming a basis of denial of this use. I think it's important to note that at the outset of this case, the applicant came before the Planning Commission on 3 separate occasions, and then the 4th occasion they voted to approve their decision. But on the first occasion, they continued the hearing. On the second occasion, the village asked for a traffic study. So this all came about, the importance of a traffic study, the significance of that for the site was something that was their idea. We need you to get an expert to analyze this in an objective way and tell us whether it's adequate. They gave them only 2 weeks, and they did so. When they returned that report, it was, I believe, I'm going to get the dates wrong, but there were several days between, it was like June 29th, they show up at the Planning Commission. The village provided right there, then and there, a traffic study by their village engineer that was dated several days earlier, that they did not provide several days earlier, that provided them several conclusions to evaluate at the meeting. Those conclusions did not recommend a denial by the village engineer, their only expert presented on the record. It provided 4 details: that the volume of traffic was, quote, close to warranting a left turn lane, that it is unclear what weekend impacts would have on the activity. It is, quote, unclear if the vegetation impacting site distance can be adequately addressed. And the 4th being that the proposed driveway spacing in relation to Edith is a safety concern. Their engineer then did not recommend denial, but said he would not recommend approval. With this sprung on them, they then proceeded to have the remainder of the Planning Commission evaluation of this matter, and it was denied. When this came before the BZA, it was de novo, and it was at this time that the applicant decided that since they needed to adequately address the issues in the village engineer's report, they would proceed to do that with a second traffic engineer. Mr. Flume then proceeded to evaluate this site in a way that was as burdensome as possible, given all the variables. And again, this was all prompted by the village saying that a traffic study was required. And so they took that very seriously, understanding that Church Street is a busy street. And with that, they waited until the traffic at Church Street would be at a peak rate during the school year. So they asked to postpone the hearing. With this, they determined the Church Street traffic counts. They determined what they decided would be the estimated trip count for the use, and concluded that the level of service at this site, consistent with their first engineer that the applicant presented, would be somewhere in a level of service A or C, which is considered acceptable by traffic engineering standards. Mr. Flume then addressed point by point all of the village engineer's traffic concerns. This is significant, again, because this is requested by the village, an empirical, objective evaluation of the traffic impact of this use. Mr. Flume took it a step further because he acknowledged that this site, as proposed, is not a soccer field. The traffic engineers customarily use the, quote, trip model manual for uses if they need to evaluate what a use might do on any given street as far as trip counts are concerned. The first traffic engineer and the village traffic engineer both you decided to use the soccer complex model, which is for a use where you've got soccer games, you've got spectators and people coming and going. Mr. Flume recognized that this site is unusual because it's not for soccer games. It's for soccer practices on drills where there's no regulation field, run at very regulated, spaced out, intermittent times. And so he had the good fortune to be able to evaluate the Otto Armleder Park preseason practice, where they got good data on 4 of the 6 practices. And they were able to conclude that the vehicle occupancy rate was somewhere between 1.1 and 1.2 kids per vehicle. To be conservative with that, he rounded down to 1.0 when he did his analysis. That being more conservative because if you have, say, 2 kids per car, fewer cars need to go to the site to get everybody there. And so with what was the most conservative time of year where the traffic counts would have been most burdensome, with a much more accurate traffic trip calculation model created from real-time data, rounded down to be more conservative, he then was able to conclude, consistent with the original traffic engineer, that the level of service would be adequate. And in addition to that, there would be the ability to space out the practices and have that as a condition of the use. The idea that someone as a layperson testified to this is contrary to, as we've cited in our brief, the Shelley Materials case properly acknowledges that, sure, laypersons have the ability to testify about these matters, but where there are technical matters concerned, you need to have a reliable quantum of evidence showing the impact of a use on the site. And the fact of the matter here is that I agree that the Village of Newtown residents and their chief could testify to and show that there was probative evidence that Church Street itself has a traffic problem, or that Mr. Sigmund across the street has visibility issues with his driveway. But the village frames it in a way to make you believe that because all of these things exist, despite the fact that the traffic engineers, plural, that they requested and who were able to conclude that this site could be adequately serviced in that environment, they would have you conclude that that is a burden to be borne solely by this property owner. And we do not agree with that and don't believe that the evidence supports denial of the conditional use on that basis. Another factor that the village relies upon heavily is that they believe this to be direct evidence. They say that this is unique because this operation occurred for 2 years prior to seeking a conditional use. The cases that we cite in our brief regarding direct evidence, particularly Phalang, the Butler County and Adelman Real Estate, specifically analyze the direct evidence issue and state that direct evidence is the opposite of circumstantial and is complete in and of itself and does not require additional facts or inferences to make it sufficient as proof of fact. This is a unique situation where the applicant and their predecessor owned only what I call the rear parcel that was accessible off of a side street for those 2 years. They didn't have conditional use approval. They didn't have access as they've proposed. They didn't have driveways. They didn't have any conditions imposed. They had no parking, no shelter for parents to perhaps stay and lessen the traffic burden. They had no turnarounds, no landscaping buffers. They had nothing that is proposed for this site. And the site as proposed has never occurred here. And so to call this direct evidence is improper because it requires them to insert facts to say, if you were to do all of these things, even despite the testimony that states that this would make that site adequately supported, we think that it would be exactly the way it was before, and we have no reason to suggest otherwise.
Ma'am, let me ask you a question about appellant's assertion that the magistrate did not conduct any analysis in her decision. How would you respond to that?
I would disagree. In her decision, she runs through the traffic analysis first, and by stating that, as Ms. Supinger had stated, there was a reference to experts. And the appellant says, well, this is all about, well, you have experts and we don't. And so that's what the magistrate sided with. It was about the fact that the law supports the fact that when there are technical matters, those should be supported by adequate evidence, and experts are able to provide that. And the magistrate was able to provide that and cite to that in the decision. And in support of this, also the paragraph 37 of the magistrate's decision, much of the opponent testimony was precisely of the speculative type, and it requires additional facts or inferences. We believe the decision analyzes the fact that there was a traffic study required. There were 2 traffic experts provided. There was not anything rebutted by anybody when that was what the village placed emphasis on from the outset. And that the only testimony provided by anybody in opposition to this use was speculative. And that's significant because this is about whether the preponderance of the evidence supports the denial. And at the end of the day, none of these, the compatibility issue and the traffic issue, namely, are not addressed in any meaningful way by any of the opposition, other than to speculate on things based on past experiences that are not in any way like what will be proposed at the site. And so I believe that the magistrate has adequately analyzed that.
Thank you.
And as far as the conditional uses are concerned, another thing that the appellants have asserted is that the conditional uses are, this as a conditional use is conflated with the permitted use. That is not in any way what the analysis on the record does. The analysis on the record highlights the permitted uses because in this unique case, that's significant. Excuse me. The club use in Newtown is a conditional use in the residential district. And they were correct to make it that way. A club use could take on any number of wide-ranging characteristics, some of which may be very compatible for a residential district and some of which may not. And as the record mentions, there is the Ivy Hills Country Club down the street that is in a residential district. This is the sort of thing where a conditional use hearing is exactly the type of thing that would be appropriate for any type of club use to evaluate the factors. But what makes this one unique is that this conditional use, club use, as proposed, is actually less impactful than even those uses that Newtown has deemed permitted as of right in its district. And so they're not saying you need to just permit us because you've permitted these things. It's that we've shown you through the traffic impacts and the characteristics of the use as proposed, that it is the same or less impactful than the things that you have deemed compatible as of right with your district. And the things that the permitted uses have that are significant, these are residential, parks, churches. The parks and churches merely—
Attorney Ryan, just want to let you know you have about a minute left.
Okay, thank you. Parks and churches as accessory to their uses may have not only children's soccer practices, but spectator matches. And so where you have a very unique low impact use that takes up only 10% of the pervious surface area, occurs only a few hours a night, 3 days a week, a few months out of the year, and does what is on the permitted use, is part of the permitted uses on any given day, that to me is probative of the fact that this is, in this case, as proposed, very compatible with the district. And when the village decided it was not, they did not evaluate what the standard of C6 says, location and size, nature and intensity, and location of the site. They simply said, we find it disruptive. We find it we find that there are other uses more mutually beneficial. But those aren't the analyses that should be taking place when the C6 standard goes through point by point what you should be evaluating. And in comparing these with proposed uses, or permitted uses in the code, we were simply highlighting the location and size and how that is adequate for this site, how the nature and intensity is unique and very low impact compared to what they would normally contemplate for this site. And we also took a great deal of time to show that the traffic as proposed would be adequate. And again, the 200 car trips per site, that is not a standard. That is a traffic standard recognized by any traffic engineering experts. That is simply an arbitrary number. 200 sounds like a lot, but what does that really mean? And so when
Ryan, if you want to go ahead and wrap up.
Okay, thank you. So again, the traffic engineering expert methodology is what gives that sort of number context and lets you understand from an objective standpoint. And we believe that is highly probative. And the magistrate was correct to find that the record supported approval of the use. And she was correct in reversing the BZA's decision. Thank you.
Thank you. Attorney Supinger.
Thank you, Your Honors. I'd like to highlight a couple issues here in rebuttal. The first is that a lot of time was spent talking about the fact that the Planning Commission requested the traffic study. This is because back when the original conditional use application was pending, there was no information about exactly how the property was going to be used. At that point in time, the soccer club had not submitted a copy of its schedule or told the members of the Planning Commission the number of participants it was going to have per session. None of that information was available. Planning Commission had no information whatsoever on which to base its opinion about whether or not it met the requirements of the zoning code regarding the traffic impact. However, when the case was heard by the BZA, at that point in time, the soccer club submitted to the board a schedule that said, here on Monday, Tuesday, Wednesday, Thursday, and Friday, we are going to have one practice that's going to start at 5 o'clock. It's going to end at 6:15. We're going to have a second practice that starts at 6:30, and it's going to end at 7:45. And we're going to have 50 kids max per session. That's the type of information that the board can rely on and use its real life experiences to understand what that traffic impact would be. And it then combined that with the information provided by Mr. Flume that said, this is the number of trips we have during our peak hour. We have approximately, I think it was 800, maybe 1,000 trips during the peak hour. What it came down to, though, by doing simple math, is that if you add, let's just assume that every parent drops off a kid and leaves, and every parent picks up a kid and then leaves. And then they do it again at the second training session. We know that that's 50 cars in and 50 cars out, and another 50 cars in and 50 cars out. And that's information that the board can reasonably rely on in making its determination. And it doesn't differ drastically from what Mr. Flume testified to. The main point of disagreement with Mr. Flume is that Mr. Flume said that a 12 to 13% increase in traffic should be acceptable to the village. And that's the board's decision to make. A 12 to 13% increase during the highest peak hour on a 2-lane residential street that will adversely impact the neighboring property owners is not something that the village has to agree to. There are lots of other uses that wouldn't have that same sort of traffic impact during their peak traffic hour. Additionally, the appellees contend that the testimony of the neighbors is speculative because it didn't have to do with this specific driveway that's now being proposed. That in the 2 years prior that the soccer club used it, it was not using this driveway, and therefore the experiences are purely speculative. Well, Your Honors, the soccer club first parked at St. John Fisher Church, which is located just to the south of the proposed driveway. And after that, they accessed the property on West Jefferson Street. which is just to the north of the proposed driveway. The appellees are trying to get you to think that this is somehow dramatically different, and that these prior experiences don't in any way relate to what the new proposed driveway would do. And Your Honors, that's simply not the case. We know what the traffic was like. We know what the traffic will be like. It doesn't change the number of cars coming and going. It's just where they go in. And in fact, the offset of the proposed driveway to Edith Street actually makes this worse, not better than the previous experience. So Your Honors, thank you very much for your time. For the reasons that we stated here, and we believe that the magistrate's decision and trial court's decision should be reversed. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue you a timely decision. And we all wish you a wonderful afternoon.
Thank you, Your Honor. You too.
Thank you.
Silence your pen.
Got it. Yeah, let's move it back a little bit.
Silence.
Yep. Good.
Good morning.
Good morning.
This is our second case scheduled for argument this morning. Case number C200437, ProMag Technologies LLC versus Fabrication Automation LLC DBA as Fast Machine Tools. If attorneys can please identify themselves and their readiness to proceed.
Yes, Your Honor, my name is Patrick O'Neill. I'm counsel for the plaintiff appellant ProMag Technologies, Inc.
Good morning.
Your Honor, my
Morning.
name is Tom Stackler, and I represent the appellee Fabrication Automation LLC.
Good morning. Attorney O'Neill, would you like to reserve time?
I would, Your Honor. I'd like to reserve 4 minutes of time for rebuttal, although I don't know that I'll need all that time.
Okay, well, you can start whenever you're ready.
Thank you. Your Honors, this case is about the ability of a foreign limited liability company to maintain an action in the state of Ohio when it is admittedly not registered with the Ohio Secretary of State in accordance with a revised code section 1705.58, but where the activity of the foreign limited liability company is neither permanent, continuous, nor regular. Now, this court reviews the trials court entry.
Mr. O'Neill,
Yes,
Mr.
ma'am.
O'Neill, didn't the contract here at issue, didn't that anticipate that the presence in Ohio would be continuous?
It did anticipate that there would be a presence in Ohio, and the court is right. The contract called for a sales service area in Ohio, Pennsylvania, and parts of southwestern New York. Unfortunately, there is nothing in the record that shows that there is any permanent, continuous, ongoing, or regular activity, whether the parties contracted to perform such activity. There's nothing in the record to show such activity was in fact performed. Appellant is a Pennsylvania limited liability company. It's in the business of providing and representing various technology manufacturers. As I understand Appellee's work, it's in the business of manufacturing technology-based products, and then it either sells those products directly to an ultimate consumer or employs companies like ProMag to sell its products in Ohio and or other jurisdictions. I'd like to speak briefly about the procedural history of this case, simply because, as the court can see from the record, it's a little bit convoluted. On May 7th, 2020, ProMag filed its complaint in the Hamilton County Common Pleas Court, alleging 3 causes of action: breach of contract, unjust enrichment, and failure to pay commissions in accordance with revised code section 1335.11. In response, the appellee filed a motion to dismiss, or alternatively, a motion for summary judgment with supporting affidavits. Again, at the heart of the motion for summary judgment, and I think at the heart of this case, was that appellee or defendant at the time's argument is that appellant was precluded from bringing suit pursuant to revised code section 1705.58, as it was not registered with the state of Ohio, and therefore it lacks standing to bring the lawsuit. There was some confusion, and there remains some confusion, frankly, about who the correct defendant was in this lawsuit. In response to the motion for summary judgment, PROMAC responded to that motion and then also filed a motion to amend its complaint, a motion to add parties, specifically to add the parties that defendant claimed was the real party in interest or the real defendant in this action. But I mean, it makes a difference, but not really, because at the end of the day, this case is about the application of revised code section 1705.58. The confusion regarding the actual defendant in this action is because it was on a letterhead of a different company, but it was using the trade name of the defendant in this action. So before we were able to perform any discovery or determine who may have been the real party in interest, the court ultimately ruled on the motion for summary judgment in favor of defendant. I don't think it's important to go through, I will if the court wants me to, but I don't think it's important to go through necessarily the registration issues. There were registrations using the name Fast Machine Tool by not only the defendant, but also by the party that the defendant claims is the real party in interest. I would argue to this court that the plaintiff or the appellant has the requisite standing to bring this lawsuit. It's not triggered the application of revised code section 1705.58. There's no evidence in the record that the appellant conducted business or transactions within the state of Ohio. And nor is there any record that the appellant was engaged in permanent, continuous, or regularly conducting business in the state of Ohio. The simple execution of a contract, one which was signed by the appellant in the Commonwealth of Pennsylvania, cannot constitute transacting business as that term is understood by the statute. As we've discussed, the contract clearly demonstrates that appellant's contract was for territories in Ohio, Pennsylvania, and areas of Western New York. Nowhere in appellant's complaint or the unfiled amended complaint, which was because of the procedural aspects of this case was never filed, was there any allegation that the monies rightfully owed to appellant was for business transacted in the state of Ohio. Further, defendant appellee's only plausible reference to appellant's business conduct in Ohio is maintained in the affidavit of Skip Doyle, which was attached to the motion to dismiss or alternatively.
Mr. O'Neill,
Yes,
I have
ma'am.
a question on something that you just said. Where was the sale upon
Well,
which this case is based?
Right. Well, that's interesting because according to the appellee, there was no sale. That the sale was performed by a outside third agency, Savagani America, and that really goes to the crux of is the defendant, or is the plaintiff, excuse me, the appellant, entitled to any commission on that sale. So I would concede that the complaint makes the allegation that we're entitled to a commission, and as I understand the defendant's position, of course, there was not really any discovery performed, so it's hard to say exactly what their position is, but as I logically understand it, it would be that that sale was not performed by the plaintiff and was instead performed directly by a third party. But in defendant's appellee's only plausible reference to that business conduct by appellant in Ohio is in that affidavit of Skip Doyle, and at paragraph 7 of that affidavit, it only avers that the failure to properly pay appellant was the single sale of a product manufactured and sold to a customer by Salvagani America, which is located in Hamilton, Ohio. Notably, as I've just said to Judge Bach, that this sale is at, as far as I can tell, is at the center of the dispute of whether my client is entitled to a commission. But really what the case has turned on, there's a lot of stuff flying around there, but what this case is really turned on is can the appellant and the plaintiff in the action maintain a cause of action in the state of Ohio when it's not registered with the Ohio Secretary of State. I think that if we look at the court's decision that it rendered, that on page 4 of that decision, it cites to the case of State ex-rel Physicians Committee for Responsible Medicine versus Ohio State University Board of Trustees, 108 Ohio State 3rd 288. And it cites a fairly lengthy paragraph in that decision. And it says, it cites the Supreme Court and quotes the Supreme Court saying, it's well recognized that a foreign corporation transacts business within the state when it has entered the state by its agents and is there engaged in carrying on and transacting through them some substantial part of its ordinary or customary business, usually continuous in the sense that it may be distinguished from merely casual, sporadic, or occasional transactions and isolated acts. This court has similarly suggested that a foreign corporation's activities must be permanent, continuous, and regular to constitute, quote, doing business in Ohio as applied to the statute. Now, that is the standard, and I think the trial court was right in identifying the standard. Unfortunately, simply in the next paragraph, the court misapplied the standard, and it said that Promac, my client, was in the beginning stages of continuous activities on behalf of Ohio businesses in a sales region that included Ohio. Well, the beginning stages of continuous activities is not continuous activities. No more than the first 100 yards of a marathon is a marathon. It may have been beginning the continuous conduct of activities in Ohio, but it was not engaged in continuous activities in the state of Ohio. Neither was it engaged in regular activities or ongoing activities in the state of Ohio, so that the implication and the application of Revised Code Section 1705.58 is inapplicable in this scenario until a determination is made that.
Attorney O'Neill, let me ask you this, because embedded in that beginning stages of continuous activities is, I read into that the trial court is saying that Promac was acting with the intent for the activity to be permanent, continuous, and regular.
And
so that you get what my question is. So is intent enough?
Yes, ma'am. And I agree with you. I think reading between the lines, that's what the trial court that's what its reasoning or its thinking was, that Promac was on its way to engaging in continuous activity, and that was its intent. If that was in fact its intent, it's not clear in the record, and that the record is what we're looking at. But if that was Promac's intent, it still had not engaged in that threshold of continuous, permanent, or ongoing activity. And if it was the intent of Promac, it could have subsequently, and this goes to an equity argument, it could have subsequently registered with the Ohio State, with the Secretary of State of the state of Ohio, if it intended to more than begin the stages of continuous activity and actually had engaged in such continuous activity. But that that's probably guesswork on my part to determine what the court was trying to do here. I think the court, frankly, if we go back, I think the court made a mistake in putting not literally, but almost literally putting the cart before the horse and allowing Promac to amend its complaint, or saying it would allow it to amend its complaint and add parties, and then pulling the rug out from under its feet and determining that it was unable to state a cause of action because it was not registered with the Secretary of State. But as I've said before, I think that's the linchpin of this whole case is, was PROMAC required to register with the Ohio Secretary of State, where there's no finding by the court other than engaging at the beginning stages of ongoing activity. Is that my time?
No, I'm sorry, that's my.
Oh, okay. No problem, Tom. No worries. I would also point the court to.
But you know what? You are out of time, actually.
Oh, okay. Well, thank you.
Thank you.
Okay.
Okay,
Well,
Attorney Stakler, whenever you're ready.
Yes, may it please the court, your honors, and Mr. O'Neill. It appears that what Mr. O'Neill is arguing on behalf of his client is really what is found in his third assignment of error. And as your honors know, we placed our argument regarding the third assignment of error first because we believe that that really is the crux of this appeal. And it has to do with whether or not the trial court erred in granting summary judgment for fabrication automation on the basis that PROMAC technology is not registered with the Ohio Secretary of State when it should, because it's transacting business in the state of Ohio. Here's the problem, your honors. The problem with the appellant's argument on appeal, what has been said today, that it is different than what it said in the trial court below. In fact, it did not argue in the trial court below. It did not provide or offer to the trial court, after having an opportunity to do so, proper Civil Rule 56 evidence as enunciated in Civil Rule 56C. Now, what are we talking about here? The rule says if you are going to present evidence to the trial court in favor of or in opposition to a motion for summary judgment, that evidence has to be the pleadings, depositions, answers to interrogatories, written admissions, affidavits, transcripts of evidence, and stipulations. None of that was offered to the trial court. The only thing that the plaintiff, the appellant, ever stated is found on page 5 of its memorandum in opposition to the defendant appellee's motion for summary judgment, which it says in passing, and this was in reference to one of the cases, Harris versus Rossi, that we've distinguished along with the other two. But in discussing the Harris versus Rossi case, PROMAC says we're not transacting business in Ohio. Well, that's all fine and dandy, your honors, but that's not evidence of the nature that's found and required under Civil Rule 56C. And I think that's what Judge Callan was referring to down in the court below. What happened is that we filed a motion to dismiss under 12B6 for failure to state a claim upon which relief can be granted. We asked the court to convert that to a Civil Rule 56, primarily because we supported our motion with material that was outside the four corners of the complaint. And that was the evidence that we presented by way of affidavit. The trial court did, in fact, consider that evidence outside of the pleadings and converted it to Rule 56. At that point in time, it was incumbent upon the non-movement to fulfill its obligation as required under Civil Rule 56 once the movement fulfills its obligation. And what did we tell the court? We told the court, number one, that PROMAC was indeed a foreign limited liability company. Two, we told the court that they were transacting business in the state of Ohio. And what were we saying there? We were saying, this is our subagent, your honors. This was an entity by its own admission in paragraph 22 of its complaint, can state over 450 plus or minus emails with either Fabrication Automation or its sister entity, Fabricating Systems and Technologies, Inc. All of those communications, all of them had to do with one or another aspect of PROMAC's relationship with these Ohio entities as its subagent. This was a subagent who was hired as a sales representative in an assigned territory that included the state of Ohio. Your Honors, it would be absurd to think that this company, Promax, was not transacting business in Ohio when they entered into a contract with Ohio entity to do just that. That's what they were hired to do. The contract clearly says that their exclusive territory includes the state of Ohio.
Attorney Sackler,
Yes.
I assume that you agree that the trial court had determined that Promac was in the beginning stages of continuous activity.
You know what? I don't think that it was the beginning stages. I think that
I assume that you agree that the trial court had determined that.
Yes, I agree. I think that
So
the trial
with that finding of fact, right? With the trial court making that finding of fact, and I think that's really the premise of the whole argument of Attorney O'Neill, is that that finding of fact is contrary to the standard that must be met here.
I think that you are correct. That's what Mr. O'Neill is referring to. But what I'm more concerned about is that why any of these arguments weren't presented to the trial court below. None of this was.
Well, I mean, the trial court makes that determination. I don't know that the time to make the argument on the determination will be before us.
No, well, what I'm saying, Your Honor, is that the record is absolutely devoid of any evidence that one should offer, that is required to offer under Civil Rule 56.
No, and I understand that, but I understand your argument. I truly do.
Yep.
But I'd like for you to address Attorney O'Neill's argument, because I think the way he would respond to that is notwithstanding the fact that we didn't submit any of the required evidence in the response to the motion for summary judgment, the determination by the trial court in this finding of fact is contrary to the outcome.
Well, what I would suggest here is that when I read State XREL Physicians Committee, which sets out that the transacting business in the state of Ohio has to be something more than just casual, sporadic, or occasional transactions or isolated acts. This is not. The evidence does not show that what was happening in this case by Promax was casual, sporadic, or occasional transactions or isolated acts. And I think that's what the trial court was alluding to. Yes, they were in the early stages of their relationship, but the early stages of their relationship was still nonetheless continuous. They were working together. This man was hired. The record is clear that he was a sub-agent working for, they say fabrication automation, and that's a totally different issue. It's fabricating systems and technology, but I'm not even going to get into those particular issues. I think that the record does contain sufficient evidence to establish that Promac was indeed transacting business in Ohio.
Thank you.
So, with that said, I think that really this appeal rises and falls on what we've been arguing about, and that is, did the trial court err or not err in granting summary judgment, for one of the defendants? Let me just make a remark here about what Mr. O'Neill says in terms of, I don't know what his exact words were, but he says it's like taking the cart before the horse. What the trial court judge did, Your Honors, first of all, it addressed the motion to amend, and it stated in its opinion, the reason why she did it that way is because we had already acknowledged that a non-party, which was fabricating systems and technology, we've always took the position that that was the correct party to the contract, and we were basically offering that entity as a new party defendant. And so she said, in her opinion, since the defendant has already agreed to bring a new defendant to the case, we'll address that. She then went further and said, I'm going to allow the plaintiff to add a new cause of action which was fraudulent inducement. She did not allow the second proposed claim, which was a claim for piercing the corporate veil, because the court concluded, and I think rightly so, that's not a cause of action, that's a remedy. But the point is, as it stood, the motion to amend was granted. All that the plaintiff had to do was refile an amended complaint. It didn't matter to them. In regard to the claims against fabrication automation, the court certainly is not going to entertain a defense such as the one that fabrication automation brought to the case, which is the defense under 1705-58. The court said, in her opinion, that that particular defense, the defense where a defendant says the plaintiff doesn't have standing, that can be waived. And so she certainly is not going to assert a defense that might be available to the new defendants once they're in the case. The new defendants were never brought to the case, and therefore there was no issue in regard to them. So, you know,
Mr. Steckler, Mr. Steckler, I just want to clarify something. If this court decides that the summary judgment was improper and reverses and sends it back, are you arguing that that the other entity, I think it's Fabricating Systems, should, or that the trial, are you saying that the trial court improperly permitted an amended complaint?
Absolutely not, Your Honor. Absolutely
Okay.
not. You know, what I'm saying is, I mean, to answer your question, if this court were to address the third assignment of error, I don't think that it's going to reverse it. But if you were inclined to reverse and send it back down to the trial court, then the court would be, in essence, saying that PROMAC does not need to be registered with the Higher Secretary of State because it's not transacting business. At that point in time, the unanswered issue by the trial court is who is the proper party to the contract. The court didn't even address any of the issues that are contained in the first and second assignment of error. You know, and I'm referring to, well, did PROMAC agree to contract with Fabrication Automation, or instead did it agree to contract with Fabricating Systems and Technology? All that stuff is something that the trial court is going to have to address. But I don't think it's going to get that far. I mean, I don't think when you have a situation like this where a plaintiff is the non-movement party and is facing a motion to dismiss, it does nothing. It offers no evidence at all to the trial court to consider, zero. But then waits until appeal and says, okay, well, here's what I really think about transacting business. What has happened there, Your Honors, is that he has not given the trial court an opportunity to consider whatever facts that he believes places a general issue of material fact in the case. She says quite clearly here, in response, it says, additionally, PROMAC's response was its reasonable opportunity to present all materials made pursuant to such a motion by Rule 56. And then she goes on and say that once the non-moving party fulfills its burden, the non-moving party presents no evidence to support the merits, summary judgment is proper. And that's where we are in this case. You know, you just can't sit on your hands in the trial court and make some legal conclusion, well, we're not transacting business, and not put by way of affidavit or some other well-recognized Civil Rule 56 evidence to create for the trial court judge a genuine issue of material fact. This didn't happen here. So the court was left with no alternative other than to look at the facts as set forth by the movement and conclude, well, okay, I believe that PROMAC has indeed transacted business in Ohio, and she explained why she believed that to be the case. And that's uncontroverted in the evidence.
Thank you.
Yes.
Was there anything further?
Not from the appellees.
Okay, thank you, unless there's any questions. All right. Attorney O'Neill.
Thank you, Judge. I want to respond to a couple of statements made by counsel. PROMAC could not have filed an amended complaint. There was no opportunity to file an amended complaint. The dismissal or the granting of summary judgment was contained in the same entry that was going to permit PROMAC to file amended complaint. So because it was in the same document and filed at the same time, there was no way that PROMAC or the plaintiff, the appellant in this action, was going to be able to file an amended complaint. That simply procedurally could not happen. There's been some discussion about Rule 56. As this court is well aware, and I don't need to inform it, it determines this case, this appeal de novo. Whether or not the appellant came forward with any sufficient evidence under Rule 56 is entirely immaterial. It's immaterial because the court on its own determined that Promac was in the beginning stages of conducting continuous activities. It didn't find that Promac was engaged in continuous activity. It made no determination whether it was engaged in permanent or regular activity or any ongoing activity. And as I've said before, they got the standard right. The court misapplied the standard. So this idea that they came forth with evidence, let's talk about the evidence they actually came forth with. They came forth with one affidavit indicating a single instance of activity in Ohio that it didn't pay my client its sales commission, said somebody else did it. So
Mr. O'Neill,
yes, ma'am.
do the emails, the 450, approximately 450 emails, is that not transacting any business in Ohio, or was that?
The emails themselves are not transacting business in Ohio. The emails are not in the record. They're not something that can be reviewed. The parties had been exchanging emails for quite a long time, but it's not in the record, so I hesitate to even address that. But it was about selling in other jurisdictions other than the state of Ohio. I have very limited time, Judge, and I hope I answered your question, but I want to also say that the appellee cites the case of—
You have less than a minute left.
Okay, of Harris v. Rossi. Harris v. Rossi stands for the same proposition set forth in Physicians Committee. Harris cites to the Premier Capital LLC v. Baker case, which defines transacting business as when a business agents enter the state and regularly conduct and transact some substantial part of its customary business, usually continuous in the sense that it may be distinguished from casual, sporadic, or occasional. Again, there's no finding that Promac or the appellant engaged in anything other than casual, sporadic, occasional, and that's set forth directly in the court's entry. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. And we wish you both a wonderful afternoon.
You too.
Thank you, Your Honors.
Bye now.
Thanks, Tom.
Bye-bye.
All right, thanks, Matt. Very good.
Good morning. We are now here on our final case set for argument this morning. Case number C210240 to Keitha Johnson's versus Cincinnati Metropolitan Housing Authority. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Jeff Mando on behalf of the appellant defendant, Cincinnati Metropolitan Housing Authority. We are ready to proceed.
Good morning.
Elizabeth Achani on behalf of the plaintiff appellee, and we are ready to proceed.
Good morning.
Good morning.
Attorney Mando, would you like to reserve time?
I would, Your Honor. I'd like to reserve 3 minutes for rebuttal, please.
Okay, you can start whenever you're ready.
Thank you. May it please the court, Ms. Acciani. We're here today on an appeal from a denial of CMHA's motion for summary judgment in the trial court. CMHA sought summary judgment based upon its political subdivision immunity under Ohio Revised Code Chapter 2744. There is no dispute that CMHA is a political subdivision of the state. Plaintiff acknowledged that point before the trial court, and the trial court acknowledged it. Likewise, there's no dispute that the general rule of immunity would attach to CMHA in this particular case because the operation of a public housing authority is a governmental function. The sole question then is whether or not this particular case falls within one of the limited exceptions to immunity, as those exceptions are set forth in section 02B of chapter 2744. And specifically, the issue before the court is very narrow. The question is whether or not it's really a question of statutory interpretation. And it's a question of whether or not a misplaced floor mat in Ms. Johnson's unit at 519 Hickory Street constitutes a physical defect within or on the grounds of buildings that are used in connection with the performance of a governmental function. So it's really a question of whether or not a misplaced floor mat is a physical defect, as that term is used in B4 of the statute. The trial court never directly addressed that issue in ruling on the MSJ. Instead, the trial court said whether the defect was caused by employee negligence, i.e. employee negligence of CMHA, presented a conflicting issue of fact for the jury to resolve. So it never really addressed the question, the pivotal question of statutory interpretation of whether or not this misplaced floor mat constituted a physical defect.
Now, you're characterizing the floor mat as misplaced. What's the evidence in the record that it was misplaced?
The evidence in the record is from Mrs. Johnson's deposition testimony, in which she said that it was not in its place. She said that it could be moved back into place. There was not anything physically wrong with the mat itself. She was aware of it and actually pushed it back into place on occasions in the past.
But was her testimony with regard to the mat before she had fallen? Because it seems as if the picture that was presented to her seemed to be after she had been injured, the picture of the mat.
Her testimony was she was aware of that before.
Well, she was aware of the movement nature of the mat before. I think that that's clear from the record.
Yes, ma'am.
But you characterized it as a misplaced mat, which I interpreted as at the time of the injury, it was misplaced. But perhaps you meant something different.
Yeah, by misplaced, Your Honor, and I'm not trying to be cute with words, I'm trying to say it was not in the place where it was intended to be. But there was nothing physically wrong with the mat itself. And from that standpoint,
it was not in the place that it was intended to be. Are you talking, again, I just want to make sure we're on the same page. Are you saying that at the time that she stepped onto the mat, at that time, or I should say before she even steps onto the mat, it is not where it was intended to be? Or are you saying upon stepping onto the mat and its movement, the movement when she steps on, it creates it's not in the place it's intended to be?
my understanding and review of her deposition testimony is it's the former.
Okay.
As opposed to the latter. And in looking at what the courts have said,
before she even placed her foot, it was already where it should not be.
That's my understanding and my interpretation from her testimony, and viewing the facts in the light most favorable to Ms. Johnson, which we had to do in pursuing our motion for summary judgment. And it's in looking at the case law as to how courts defined and construed what the General Assembly meant by physical defect within B4, it has to be a perceivable imperfection that somehow diminishes the worth or value of the object. It has to be something that means that it was not did not operate as intended due to a perceivable condition. Well, this mat worked fine when it was in place. It was arguably not where it was supposed to be, but it was not diminished in value, and it was capable of operating as intended. So from that standpoint, it doesn't constitute a physical defect, and it's more analogous. There's been several cases.
Again, I'm still a little confused now, because you're saying that the mat worked fine when it was in place, right? And we've already defined that at the time that it was out, you're saying that it was out of place before she stepped onto it, right?
Yes, ma'am. That's the way I construe her testimony.
Okay, so if you're saying it worked fine when it was in place, I believe that you also had stated that she had testified that when she stepped onto the mat would move and she would put it back into place.
No, I don't. I think she testified that she was aware that the mat had been out of place before, and that she would push it with her hand or her leg back into place, is what she said she did. And my understanding from the deposition testimony is that it was not in its intended place at the time she stepped on it when the accident occurred.
Mr. Mando, let me ask you, and I may have read this in to the facts, but was this mat supposed to be affixed in some manner to the step? I mean, stapled down, nailed down, or something glued down, something like that?
I think it's fair to make that assumption that it would be attached in some way, Your Honor. Yes.
All right, thank you.
I cannot say otherwise in good faith. All right. But it's still, when you look at, I think it's a question of statutory interpretation. I said at the beginning, do we broadly construe physical defect under the General Assembly's adoption of this language, or are we looking at the text itself and how it's been interpreted so far in a more narrow view? That really, I think, is the question for this court on appeal. And again, this particular mat itself, there's nothing wrong with it itself. It's not diminished in value. There's no perceivable defect in the mat itself. It works as it's intended to do. And Ms. Johnson knew that. She knew it had been out of place and she had moved it back in the before. And so from that standpoint, I think this case is more analogous to the O'Brien versus Great Parks case that we cited in our briefs, where the plaintiff was struck by a lawnmower on a golf course. There was nothing perceivably wrong with the lawnmower. It was not diminished in value. There was not a defect in it. And the court held that that was not a physical defect under B4. That's in contrast to the cases that Ms. Asiani has cited on behalf of Ms. Johnson, like the Leisure case, where somebody was injured when bleachers had not been extended and locked into place. But the key difference there in that case was that the plaintiff was not aware of it until after the accident happened. So I think that there's some contrasting distinctions there that are significant in terms of interpreting what physical defect means. So in this particular case, we contend that the trial court respectfully erred, number one, by not specifically addressing the issue of whether or not this misplaced mat was a physical defect, and that construing the statute fairly, this mat, which has no perceivable defect or anything wrong with it, does not constitute a physical defect, and therefore the exception to immunity, the general rule of immunity, does not apply. The second point of error that I want to address today has to do with the second and third causes of action in Ms. Johnson's complaint. In addition to a common law negligence claim, Ms. Johnson asserted a breach of the statutory Landlord-Tenant Act, as well as the implied breach of warranty of habitability under the Act. Those are statutory-based causes of action. In our briefs before the trial court, we raised the issue that CMHA was immune from those claims pursuant to 274402B5 and the Moore versus Lorraine Metropolitan Housing Authority case. The trial court plaintiff did not respond to those arguments in opposition to our brief. The trial court never specifically ruled on those issues, but the case law is clear, and the interpretation of B5 is clear, that CMHA would be immune to the extent that Ms. Johnson is attempting to impose liability for this particular action based upon the statutory Landlord-Tenant Act and the embedded in breach of implied warranty of habitability. So we would ask that the trial court's decision be reversed on those two respective points, and that the matter be remanded and summary judgment be entered in favor of CMHA. And unless the court has questions, I'm prepared to rest and my argument and reserve on rebuttal.
Okay, thank you. Attorney Achani, whenever you're ready.
Good morning, Your Honors, counsel. On behalf of the plaintiff, I guess the first point of clarification I'd like to make, in case it wasn't clear from the briefs, that defense argues that it's a floor mat. This mat it's a non-slip it's a non-slip mat-like substance that it was applied to the stairs. So what it does is it covers the edge of the stairs so that they could be transcended and, without slipping. Their main function was to prevent slips and falls from these staircases. So when the allegation that it was misplaced, it covers the entire stair. So it covers the top of the stair and the side of the stair. And then what happens is when it became misplaced was when how it was affixed with glue or nails or whatever it was affixed with, that became loose. And then the mat that was on top of the stairs slid off when she descended the stairs, and that's what caused her fall. It clearly it was defective in the way it was attached to the stairs. And in her testimony, she stated that she notified them during 2 occasions that these floor mats that were affixed to each one of the steps were loose, and particularly the one in general. And so she let them know that the stair mat was an issue. It was
Ms. Achani, so would you characterize the mats as actually being a part of the stairs, or are they separate?
It's separate from the steps. So if you removed all of the floor, all of the top part of the steps would still function as regular stairs. These were added to the steps to prevent the slippage.
Okay, so then one thing that Mr. Mando said was that the mat itself was still working. It was simply user error that caused it not to work. And he compared it to the O'Brien versus Great Parks of Hamilton County case, where in that case, there's nothing wrong with the lawnmower, it was user error. Can you address that, please?
Sure. There's nothing wrong with the mat if it stays affixed. So the mat didn't break apart or dissolve. The mat slipped from its intended permanent location, which caused a problem, which is more in lines with like Yater, which is the volleyball net where the bolts came apart from the thing and caused the injury. There was the perceivable defect that it was found to be a defect because it didn't really function as it should have. The stair mat should have stayed in the same location. Otherwise, if you had a movable stair mat, then it would serve no function. Nobody puts down a mat like they do at the entrance of their door on every single step. It was never intended to be a removable feature. It was permanent. And when she notified them that it was loose and it was coming loose when she transcended it and she'd have to push it back into place, they failed to fix it on 2 different occasions, despite notice. So the function of this stair mat, I guess, as we're cobbling over semantics, but the stair mat was permanent. It was supposed to stay in place. Its intended purpose was to prevent people from slipping or falling down the steps. It was a rubber-like substance which would keep traction and tread. And so if that's the point of it, is to keep from slipping, and then the mat itself slips underneath the person's step or their foot, it defeats the purpose of even having there in the first place.
So the fact that it is permanent, it's intended to be permanent. I'm going to go back to my original question. Does that make it part of the stairs? Part of the design of the stairs?
It would make.
Does it add to the design of the stairs?
It adds to the functionality of the stairs. That they could exist separately without it, but they put them in there. And in the contract that she had with them for the housing, she was not allowed to remove anything from the premise or alter it in any way. So she could not remove them to just have plain stairs. So it was permanent.
Okay. Thank you.
I think the case law establishing what the defects are, there's presented at least 6 different cases where they found that there was a defect. One was the volleyball net with the loose bolts that fell from the volleyball net. The courts have gone far as even to say another lawnmower case where the chute was missing was considered a defect. The bleachers where the person descended down, they said that they found the defect in that case as well. as well as in Williams with the pool table that collapsed, and in Brister where the gym equipment that they knew was a problem and aged, that the bolt or the cable detached and hit the person in the head, causing them injury. I think those are all very, very well-defined instances of where they found that there was a defect, and the fact that this was a non-slip mat that was affixed to the stairs and it failed for the purpose that it was intended to be installed for, clearly falls into the category of the third definition, which is our main argument here on the case, on why summary judgment was appropriately not granted on the basis of immunity for CMHA. In regards to whether or not the Landlord-Tenant Act or the rules of warranty and habitability apply to Cincinnati Metro Housing Authority, I'm not going to argue against the precedent Supreme Court case that clearly says that it may not apply to them because it's not express. So that's why it was not argued or briefed in that matter. But on the negligence standpoint, it certainly exists that there was a defect that falls under the exemption for the immunity for CMHA.
Thank you. Are there any other questions from the panel? Okay. Attorney Mando?
You're muted.
Yeah, there you go.
I think I got it. My clicker was a little off here a second.
It's okay.
Three brief rebuttal points. First, I think it helps inform the court's decision if we start with as a reminder that the general proposition is that CMHA as a political subdivision is entitled to immunity, and that in order for CMHA to be liable, it has to be fit within one of these 5 narrow exceptions to immunity. And I think plaintiff wants to broadly construe those exceptions, when I think that exceptions as a whole to immunity should be more narrowly construed. Secondly, I think at times and I've done it myself, there's a tendency to conflate the negligence issue with the immunity issue. Whether or not Ms. Johnson told CMHA that this was loose and that it wasn't in place, and whether CMHA is on notice, may very well be completely relevant to establishing whether CMHA was negligent. But it's irrelevant in deciding whether or not a physical defect existed within the building itself on the immunity analysis. And third, Ms. Asciani said there's nothing wrong with the mat itself if it stays affixed. Similarly, with that O'Brien case, there's nothing wrong with the lawnmower itself as long as it's operated safely. So I again think that case has more relevancy and has more traction in informing how this court should rule than the cases that plaintiff has cited. Thank you, Your Honor. I appreciate your time this morning.
Thank you both for your arguments. We will take the matter under submission, issue a timely decision. We thank you both again for your arguments. Wish you a wonderful afternoon. And that concludes our arguments